Welcome back. This is chapter 8, Some Reminiscence of the Bar by Mahatma Gandhi. It's a very good chapter. A lot of things to learn from each chapter. I feel I was not doing justice by going and just reading through the text in my previous videos. Although for me it is very easy to just read through and understand. But what justice am I doing for people who have subscribed? That is more important. So in this videos and any videos from here on, I'll try to go into deep analysis because that is what I like actually. Not to make it short videos, but rather make it more interesting, learn as I'm doing it. So all these videos that I'm uploading is not for others, but for myself so that I can listen to it again and again. So if somebody finds value in these videos rather long, I'll be glad. I'll be happy that they have found some value in what I'm creating. Regardless, these videos are for my own listening as well as if it helps others, good. That would be nice. Let's get back into the chapter 8, Some Reminiscence of the Bar by Mahatma Gandhi. This is from the exam perspective. Summary of the text. Mahatma Gandhi reflects on his legal experiences in South Africa before moving on to his life in India. He emphasizes, stresses his commitment to truthfulness in the legal profession, how difficult it is to be truthful, not only in legal profession but in our daily life. Here is talking about commitment to truthfulness in the legal profession, rejecting the common notion that a lawyer's profession requires deceit. They say that a lawyer's profession is a liar's profession. Lawyers are liars. And he rejects that common notion that to be a lawyer you need to be deceitful. That is, you need to lie. Gandhi recalls that he never resorted to dishonesty. He never resorted. He never turned to. Resorted means turned to or relied upon dishonesty in his legal practice, even when it meant losing cases. He avoided. So he avoided representing false cases and built a reputation that attracted only genuine clients. One particularly difficult case tested his principles. The case involved a complicated financial dispute where the arbitrators, neutral third parties appointed to settle dispute outside of the court, are the arbitrators. They are the third party outside of the court settlement. They review the evidence and arguments from both sides and make a binding or advisory decision known as arbitration award. So the case involved a complicated financial dispute where the arbitrators made a calculation error, inadvertently benefiting Gandhi's client. So the arbitrator made a calculation error and it went in favor of Gandhi's client. When the senior counsel advised against admitting the mistake, arguing that it could jeopardize their victory. Gandhi insisted on honesty. The client, trusting Gandhi's integrity, honesty, agreed to disclose the error even if it led to defeat. During the hearing, one of the judges accused Gandhi of sharp practice, implying dishonesty. Gandhi defended his position confidently, explaining that the discrepancy was a genuine mistake. The court, persuaded by his arguments, ultimately accepted the correction without invalidating the award. This experience strengthened Gandhi's belief that law could be practiced truthfully, though he acknowledged that the legal profession itself has inherent flaws, shortcomings. Next, we will critically evaluate the chapter or the essay or the writing that Mahatma Gandhi wrote. This chapter from Mahatma Gandhi's writings, so these were his writings, offers a profound insight, deep insight, intense or having great significance, a deep insight into his unwavering commitment to truth and ethical lawyering. It showcases how he maintained integrity in a profession often associated with manipulation and dishonesty. However, a critical evaluation must consider both the strengths and the limitations of his approach. The strengths of the chapter: moral integrity and ethical lawyering. These are the strengths. Gandhi's refusal to accept false cases and his insistence on honesty set a high ethical standard. His decision to disclose the accounting error, despite the potential consequences, demonstrates a commitment to justice over personal gain. This provides an inspiring model for legal professionals who face ethical dilemmas. This is very, very important: moral integrity and ethical lawyering. But how much of this we can see today in today's modern world? It's very difficult. But it gives us an inspiration to follow in Mahatma Gandhi's footsteps. Courage to challenge legal norms. The chapter highlights how Gandhi challenged conventional legal strategies, refusing to adapt tactics that could mislead the court. His confrontation with the judge who accused him of sharp practice underscores his fearless advocacy for truth, even in the face of authority. We as lawyers can learn a lot from all of these chapters. The power of persuasion. Gandhi's ability to convince the court despite initial skepticism illustrates the power of rational argumentation and moral conviction. His success in securing a fair verdict despite admitting the error proves that honesty does not necessarily lead to professional failure. Personal transformation and legal philosophy. The chapter is not just a legal anecdote, it also reflects Gandhi's evolving philosophy of truth, satyagraha. His legal practice was an early foundation for his later activism, where he used truth as a tool for social justice. Limitations and criticisms. Pragmatism versus idealism. Gandhi's strict adherence to truth raises practical concerns. In the competitive legal world where strategy and negotiation play crucial roles, his approach might seem impractical for many lawyers. His refusal to defend even slightly dubious cases could limit opportunities for legal professionals who operate within the more flexible moral boundaries. That is very subjective for each person. What is their moral boundaries? The nature of law as an adversarial system. Modern legal practice is inherently adversarial. Lawyers are expected to defend their clients' interests, even if it involves exploiting legal loopholes. By rejecting strategic maneuvering, Gandhi's method could be seen as idealistic rather than universally applicable. Third, judicial bias and professional risks. The judge's immediate suspicion of sharp practice suggests that even honesty can be misunderstood. If Gandhi had failed to persuade the court, his client might have suffered unnecessary losses, raising the question of whether absolute truthfulness is always the best legal strategy. Limited discussion of systemic issues. Since I am understanding all of these, I am not explaining in more detail. The previous chapter did require a lot of explaining, so I did that. But here, if I find something which I need to understand much better, then I'll try to explain and also understand and learn myself. While Gandhi acknowledges the legal profession as fundamental defects, he does not explore how the system itself might compel dishonesty. Factors like financial pressures, client expectations, and legal complexities often force lawyers into moral compromises. A deeper critique of the legal system would have strengthened his argument. This chapter is a compelling testament to Gandhi's ethical vision and belief in truth as the foundation of justice. His approach offers an idealistic yet powerful alternative to legal manipulation. However, from a practical perspective, his rigid stance on truthfulness might not always align with the realities of modern legal practice. While admirable, his method requires a rare combination of moral courage, client trust, and judicial fairness, conditions that may not always exist in today's legal world. Let's go into the quote. I had thought that in saying this, I had said all that was necessary as regards my legal practice. But friends want me to do more. Mahatma Gandhi to the readers. Gandhi initially believed that stating he never resorted to dishonesty was enough. However, his friends urged him to provide specific examples of how he upheld truth in legal practice. This sets the stage for the chapter's detailed account of his experiences. Quote, I warned every new client at the outset that he should not expect me to take up a false case or to coach the witnesses, with the result that I built up such a reputation that no false cases used to come to me. Mahatma Gandhi talks to the readers. Gandhi emphasizes his commitment to honesty in law by making his principles clear from the beginning. He ensured that only clients with just cases approached him, reinforcing his ethical stance. Next quote, I shall have nothing to do with the case if the error is not admitted, Mahatma Gandhi tells his senior counsel and client. This statement comes when Gandhi insists on admitting a calculation error in an arbitration case, despite his senior counsel's opposition. It reflects his unwavering commitment to truth, even at the risk of losing the case. What I understood while doing law and literature is that We are not actually doing English in this. We are actually learning a lot of legal terms like arbitration or counsel, senior counsel, opposition or defendant, petitioners, client, and so on, case laws, precedent. So, this is what we have to learn while doing literature. Also, why we are doing this? Why have they given us to do all this? Who said, to whom, what was the context? Is that as lawyers, we need to be observant. We need to remember a lot of things about our client's name, who said what. So that also always helps us in the court or in drafting. Let us lose if that is to be our lot. God defend the right. Gandhi's client said to Gandhi. The client, after some hesitation, agrees with Gandhi's ethical stance, choosing to admit the mistake rather than win dishonestly. This shows the trust Gandhi had built with his clients and reinforces his belief that truth should take precedence over victory. Next quote. Is not this sharp practice, Mr. Gandhi? A judge to Mahatma Gandhi. When Gandhi admits the error in court, a judge initially suspects him of deception. This highlights how honesty can sometimes be misinterpreted in legal settings, but Gandhi confidently defends his integrity. So we have words like misinterpreted, misinterpretation, defense, suspects, deception. So all these words are very useful for us as in our law practice. I'm surprised that your lordship should suspect sharp practice without hearing me out. So from this we can learn about how the advocates, the lawyers speak to the judge, how polite you have to be, how confident you have to be, how convincing, how persuasive you should be when you're speaking to the judge. You should be able to present your ideas, your arguments convincingly and not get angry if there are some allegations put by the judge. You should maintain your calm, your composure, and you should be able to counter it in a very polite manner. I'm surprised that your lordship should suspect, the lordship is one of the word, should suspect sharp practice without hearing me out. Mahatma Gandhi to the judge. Gandhi responds boldly when accused of sharp practice. His composure and logical reasoning turn the situation around. So you should be composed and you should logically reason out things and put your argument forth, ultimately convincing the court of his sincerity. Supposing Mr. Gandhi had not admitted the error, what would you had what would you have done? The judge to the opposing counsel. After Gandhi successfully explains the mistake, the judge acknowledges the value of his honesty and questions how the opposition would have acted if the error had been concealed. This marks a shift in the court's stance in favor of Gandhi. So this completes the chapter Some Reminiscences of the Bar by Mahatma Gandhi. Thank you very much for listening. Take care. Bye bye.